Can a compromise decree be invalid if signed by a lawyer without client authorization? Can a compromise decree be invalid if signed by a lawyer without client authorization? A 32-year-old compromise decree is set aside despite a 25-year delay in challenging it. A compromise decree under Order XXIII Rule 3 of the CPC is invalid if entered into by a lawyer without client authorization. The compromise decree was set aside despite a 25-year delay in challenging it. The Supreme Court reiterated that a lawyer has no implied authority to surrender a client's substantial legal rights. A lawyer has no implied authority to surrender a client's substantial legal rights, the Supreme Court ruled. The Supreme Court of India has held that a compromise decree under Order XXIII Rule 3 of the Code of Civil Procedure, 1908 is invalid if it was entered into by a lawyer without the client's express authorization. The ruling comes in a landmark judgment setting aside a 32-year-old compromise decree in a partition suit. The case dates back to 1989 when an original plaintiff filed a partition suit seeking a 1/4 share in ancestral property, impleading several others, including defendant number 5. During the pendency of the suit, a compromise petition was filed jointly by the plaintiffs and defendants, which was accepted by the trial court on 22 February 1994, and a final decree followed in 1997. Nearly a quarter of a century later, in 2022, the legal representatives of defendant number 5 moved a miscellaneous application under Section 151 of the CPC seeking to set aside the compromise decree, contending that it had been obtained by fraud and that defendant number 5 had never signed it. The trial court allowed the application. In 2024, a decision affirmed by the High Court, leading the legal aides of the original plaintiffs to approach the Supreme Court. The appellants argued that defendant number 5 had duly engaged an advocate, filed a written statement, and joined the compromise petition through counsel, whose wakalatnama was on record since 1992. The respondents maintained that defendant number 5 had never engaged the advocate in question, that his signatures on the written statement and wakalatnama were fabricated, and that he had no knowledge of the compromise proceedings at all. The Supreme Court examined Order XXIII Rule 3 of the CPC and reiterated that a compromise must be in writing and signed by the parties. The court also surveyed its earlier decisions on compromise decrees, noting that prior to the 1976 amendment, a compromise could be oral or written and proved through general evidence, but that post-amendment it must be in writing and signed by the parties. Is it fair to allow a compromise decree to be set aside even after 25 years if it was obtained without client authorization? Tell us in the comments yes or no.
Here's what this means for you. Always ensure that any compromise or settlement is in writing and signed by all parties involved, and never rely on oral agreements. Save this video for future reference.
Follow Legal Output on Instagram and Legal Output Official on YouTube for daily legal updates.